Morning.
Your Honor, this is Milan Sears before the court,
Okay.
and it's number, I think it's number 18 on your docket, 20 CF 489. We've reached an agreement in this matter, if I may approach.
Okay. Mr. Sears, would you please raise your right hand and be sworn? You swear the testimony you give for this court is the truth, so help you God?
Yes, sir.
Thank you. You want to admit that you violated probation?
Yes, sir.
Did you read and sign this plea sentencing agreement form?
Yes, sir.
You aware of the rights you're waiving by entering this plea? Anyone force you or threaten you to enter this plea?
No, sir.
Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here today? Are you happy with the work Ms. Rivers done for you on your case? Court finds admission freely and voluntarily entered. Court accepts it. Judge you guilty. Reinstate probation or
Community control.
community control with same terms and conditions. Except I'll add one condition, to have an ankle monitor while on community control at a cost of $1 per day, $100 court costs, and PD fee of $150. Okay? Thank you.
Your Honor, is that GPS to be hooked up prior to his release?
Yeah.
And we're reinstating for the remaining period?
Yes.
Community control?
Yes. Cecily Austin.
Yes, Your Honor. We're actually, I believe, just having an agreement right now, if I may take it.
All right.
Your Honor, if I may approach.
All right.
Your Honor, Tim Gibbs on behalf of Cecily Austin. Two case members attached to this. The VOP, as well as a new law judge. That VOP has a written plea agreement for an admission. The agreed upon sentence there is time served, and the court costs that would be imposed, we're just going to simply reduce that money to a judgment lien. And then there is a deferred prosecution agreement there for you, Judge. All the monies associated with that will also be reduced to a judgment lien.
All right, Ms. Austin, will you please raise your right hand and be sworn? You swear the testimony you give for this court is true, so help you God?
Yes.
This is 21 CF 1945 and 22 CF 2763. On the 21 CF 1945, you want to admit that you violated probation?
Yes.
Did you read and sign this plea and sentencing agreement form?
Yes.
Where the rights you're waiving by entering this plea?
Yes.
anyone force you or threaten you to enter this plea?
No,
Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here?
no,
Are you happy with the work Mr. Gibbs has done for you on your case?
absolutely.
Court finds a mission freely and voluntarily enter, court accepts it, will revoke and terminate probation, sentence you to time served, $100 cost of prosecution, $100 PD fee, all to a lien, and adjudicated guilty. And then on the other one, 22 CF 2763, you've entered into a deferred prosecution. Do I need to take a plea on this?
No, Your Honor.
So you've read this deferred prosecution agreement?
Yes, it's
You
been
understand all the terms?
explained. Yes,
Then if you do the terms within the timeframes,
It calls for 6 months, Your Honor. Originally, she was gonna be required to pay those court costs within 6 months. Due to her financial situation, the state agreed to reduce the money to a lien. So essentially, she needs to, of course, stay out of trouble for 6 months and not have any contact with the alleged victim in that case.
all right, just do that for 6 months and then the charges will go away, okay? All right? Okay.
All right.
All right, thank you.
You're good. Good luck. Yes, ma'am. DPA. Yes, ma'am. Yeah. You're good. You're good. Thank you. Thank you, Judge.
About, yes.
Your Honor, I do have one other person out of custody, Mr. Timothy Carter, 21 CF 2874. Judge, we filed a waiver of appearance. Believe that waiver was without state's objection. He lives in Iowa. We're working, still negotiating that case out. I believe the state's working on reaching out to the family and the alleged victim and her family to see if we can reach a resolution on Mr. Carter's case. We'd like to go ahead and just leave this set for pretrial on June 24th.
All right, we'll set that, that's 21 CF 2874, June 24th.
Thank you, Judge. And the remainder that I have are inmates, Your Honor.
Anybody else out of custody? Where's Mr. Williams at today?
I believe he's talking to a client.
Clients? Where's Tyler Taylor? Tyler,
File the pro se motion, Your Honor, for early termination.
all right, come on up.
Your Honor, I have spoken, I have reviewed Ms. Taylor's motion, right? Tyler Taylor?
Yes, ma'am.
I have reviewed her motion, Your Honor, and also reviewed how she was doing with probation. She has done everything that we asked her to do. Therefore, we say thank you, commend her, and have no objection to the early termination if the court certifies.
All right, this is 20 CF 3009 and 21 CF 1902.
That's correct.
Correct? All right, the state has no objection to early termination of probation, so I'm going to terminate it early. Okay?
Yes, sir.
All right, stay out of trouble.
Thank you.
Thank you. Patrick? Lyndon Patrick? We know where Mr. Russell is.
Your Honor, I'll cover for Mr. Russell. We've had no contact.
No bond capias.
Well, I looked him up on the jail list from this morning's jail list, and I saw him in custody. He was in Santa Rosa County Jail, Judge. I had an appointment to see him at 9 o'clock Friday morning. When I went over there, they kept me waiting for about 40 minutes and then advised me that he was no longer there. I thought perhaps he'd been released. I think the lieutenant I was talking to thought maybe he had been too, and then it looked like we had a hold on him here. So he should be here.
Williams, it looks like
Okay. Okay. Judge, I do have one that's out, Casey Kemp, K-E-M-P.
All right.
Casey?
This
Come on
is-
up.
This is 22 CF 884, State versus Casey Kemp.
No, no, sir. You come over by me. Yeah. Judge, his defense on these cases are these allegations going to be inability to pay. We have managed to obtain placement for him in REAP. They'll help him get a job, give him a place to live, and put him back on track. What we can do is pass it out one time, or if the state and the court are inclined to go ahead and resolve the case for a restore with condition of the REAP program, REAP will even come pick him up.
Just set it for a VOP hearing, and we'll negotiate. If we can get it to fall off the docket, we can, but we'll set it to.
All right, that's, what is the name of that program?
REAP, R-E-A-P, it's over in Escambia, Judge. Bill Cross
Okay.
started it years ago.
All right, well, we'll give him, what do you want to go to,
We already have an answer from REAP, so we can pretty well set it for any time. I
About-
think what the state needs to look at maybe is talk with probation, take a look at the financial information he's been giving, and confirm that he had an inability to pay on it.
all right, we'll go to, what about June 27th?
That's fine, Judge.
All right,
And
so
that'll
this,
be for a VOP hearing.
yeah, but y'all work it out. I think he just had trouble finding employment or something, or transportation, or whatever it was.
Basically, his mother buys groceries for him once a month. He lives on property adjacent to his dad's. He's now being evicted from that property. So REAP would be a good result for him.
All right, get that worked out, okay?
Thank you, Judge.
Thanks.
Your Honor, just so the court is aware, he's passed his termination date, so the reinstatements, y'all gonna have to work
We
on
might
something a
have
little
to-
different than that.
Yeah, we might have to terminate him and put him on a new period of supervision to
All right.
accomplish that,
Well,
Judge.
y'all
I'll
work
talk
that
with him
out.
about it and with the state.
Okay.
Okay.
Thanks.
Just come by the office, okay? I don't have time really to go over it all with you today, okay? So make an appointment and come see me like next Tuesday. Judge, I've got a hearing scheduled on Kenneth Martin. Looks like we're going to reach a stipulation on that. It's to reinstate his bond.
That's correct, Your Honor. The state has no objection to a reinstatement of all original terms.
All right, well, the court will do that then. Yeah, bring him out. Mr. Martin,
The state stipulated to reinstating your bond, so we're just bringing you out so that you'll know that's happened.
all right, I'm gonna reinstate your bond, okay? Yes, sir. So when you get out, make an appointment with the public defender to get your case resolved, okay?
Yes, sir.
Thank you.
Thank you, Judge.
The only other added resident is Mr. Roseman.
Who else, Mr. Williams?
Judge, everybody I've got is in custody.
What about Bradford Henderson?
Judge, that's the one that they discovered is at our jail, and so they're transporting him over. It'll likely take a few minutes for him to
What
get
about
here.
Michael Johnson?
Hey, Mr. Johnson. All right, Judge, I'd like to set this for contested hearing on 6/27.
No objection, Judge.
All right, 6/27.
Just one second, Mr. Medina. Judge, on Mr. Medina, I'd sent over an offer to the state. The state was thinking about it, and I haven't heard anything back.
Judge, I have to review the cases. He has 3 VOPs, so if we could kick it to the next court date, I'll have an answer to Mr. Williams by then.
What about the 6th of June?
That
Is that,
works for the
how about
state.
that?
That's fine, Judge.
Okay. Thank you.
All right.
What about Ryan Miller?
Judge, on Mr. Miller, the state has accepted the defendant's counteroffer. Okay. Now, you understand you got a right to restore you with the same conditions, plus the 30 days county jail instead of the 60. Give you credit for time served. You're going to go into get a substance abuse evaluation and treatment. The community service work that you already had is going to be set at 8 hours a month, so you have to do at least that month. And then you're going to pick up another $100 cost of prosecution for each case and $150 PD fees. Okay?
So what is that being said?
Yep, you're signing in my spot.
Oh, I'm so sorry.
Signing your spot. There you go. Okay, now your cuffs on, I can't date it for you.
Yeah, please. It's my favor.
You can keep one of these, yeah. Yep. Well, here, you separate it out, my skin's dry.
Thank you.
Okay.
Is it Ryan Miller?
Yes, sir.
This is 22 CF 1293. Would you please raise your right hand to be sworn? You swear the testimony you give for is course of truth, so help you God.
Yes, sir.
All right.
There you go, Judge.
You want to admit that you violated probation? You want to admit it?
Yes, sir.
Did you read and sign this plea and sentencing agreement form?
Yes, sir.
Are you aware of the rights you're waiving by entering this admission?
Yes, sir.
Anyone force you or threaten you to enter this admission?
No, sir.
Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here today?
None, sir. Yes, I know exactly.
Are you happy with the work Mr. Williams has done for you on your case?
Yes, sir.
Court finds the admission freely and voluntarily entered. Court accepts it. Judge guilty, restore probation with the same conditions plus 30 days county jail with credit for time served with special condition of substance abuse evaluation and treatment. Previously imposed CSW to be performed at no less than 8 hours per month. $100 cost of prosecution on each case, $150 PD fees, and that's it, I believe. And note count 1 will be null prost.
That's already was null pros. He
Done.
entered a plea to count 2 originally.
Okay. All right, get this done and don't mess up, okay?
Yes, sir.
All right,
Thank you, Judge.
God bless.
Wait, you still got to talk to them.
It said community service work that's already previously been imposed at a rate of 8 hours a month, is that correct?
That's what was recommended in y'all's violation report form.
Your Honor, the department has a new program. It's just an orientation type thing that they're asking that people who have been on probation that violate come to. It's called the Face It program. If the court's inclined to order him to attend it, we try to tell all of them to attend it, but they're not coming.
Is that a,
Or
what,
wants to jump in that.
that's a, what,
1 hour program, and they can bring their families, and we're gonna show them the kinder, gentler way to do supervision.
okay, I'll order that. All right. Yes.
Your Honor, Tim Gibbs on behalf of Mr. Kevin Bray. Judge, this is 24 CF 24CF 2408, 23CF 2409. Judge, we set Mr. Bray for a status today. We were hoping to get FDLE back. I just recently got the FDLE reports back. I need to go over those with Mr. Bray because it is going to change how we approach the case. I'd like to leave this set for pretrial June 24th.
No objection.
All right, June 24th, thank you. Philip Desch, 24 CF 490.
Your Honor, Tim Gibbs on behalf of Mr. Desch. Judge, we set him for today to try to resolve it. I do see that the state on his newest case charged him with the theft, but not possession of controlled substance, just possession of paraphernalia. I don't have an offer from the state yet. I don't think I've seen one yet.
Been sent over. And this is for a VOP hearing.
I know Mr. Dozier is set for an evidentiary today. I'm not sure if Mr. Desch was set for evidentiary.
They're both set for a VOP hearing on the
At
last board.
1:30? At 1:30?
If that's when the VOPs are gonna be heard.
I know Mr. Dozier said at 1:30, but,
We'll bring him back at 1:30 then.
okay.
See if you can
We'd
work it
like to
out.
try to get it resolved, so we'll try to
Yeah.
see if we can get a
Well, y'all
resolution.
can work it out.
I appreciate
Yeah.
that. Thank you very
Okay.
much.
Thank you.
We'll say the same thing. We can say the same thing while he's here.
Yeah, y'all can get these worked out.
Your Honor, Tim Gibbs on behalf of Mr. Jamarcus Dozier. Judge, this is 20 CF 333. We are set for an evidentiary hearing on Mr. Dozier today. I didn't see an offer sent from the state in discovery. I do see a score sheet. I did just try to reach out to Mr. Sprouse via text message on some issues that I saw. So we'll bring him back at 1:30 to see if we can
All
get it
right.
resolved, or we'll have the
Y'all
hearing.
see if you can work it out for
We're gonna come back this
Mr.
afternoon.
Dozier.
Yeah,
1:30.
To have either have the hearing or get it resolved.
Thank you.
Yeah. Thanks, yeah. Your Honor, Tim Gibbs on behalf of Mr. Brandon Dykes. Judge, this is 21 CF 1811, 21 CF 1909. Judge, we set this for a status hearing today in the hopes of trying to get some momentum on it. I do know that I'm still working on trying to set a bond hearing for Mr. Dykes on the child porn charges. I don't believe he was ever actually given a bond at first appearance because the information that was filed was a direct issue capias, and I don't know if he was actually given a bond on those. I'm trying to get that set. It's unfortunately been something that I keep putting on the back burner as I'm managing other cases. So I do want to try to get that done. I'd like to get him set for another miscellaneous date coming up, not necessarily this Thursday, but if we have another one, I think next week, to try to do that so I can set it for a bond hearing and let the court and the state know that we are intending to go forward on a bond hearing.
What about June 6th?
That works for me, Judge.
Okay.
Yeah, we can have a bond hearing June 6th.
Okay, thank you.
That way we can try to get that done.
Is Miss Flowers, we heard from her?
Yes, Your Honor, she was having,
We'll talk.
may I approach?
Jury verdict of $11.5 million for your client from a death and injury against an inflatable amusement company. Recognized in 2017 as one of the top 100
right,
civil
what
trial
about
lawyers
Austin
in the state of
Dice?
Florida, and Dixie is AV preeminent rated. Dixie Dan Paul works tirelessly for his clients, as is evident by this extraordinary verdict. If you're taking your case to trial, be prepared.
Your Honor, Tim Gibbs on behalf of Mr. Austin Geis. Judge, this is a VOP arraignment on 23 CF 2533 and 23 CF 2535. I don't know if the state had made an offer on this one yet either. It's a newer case or newer VOP.
We can get a continuance and we'll get it resolved.
About June 6th.
See it before then.
Yes, sir, thank you.
Yeah. Okay.
Ms. Ford?
Your Honor, Tim Gibbs on behalf of Ms. Wendy Boardman. Judge, she is back from the state hospital. We will likely be getting our own evaluation to confirm that, but otherwise we will be looking to resolve this. I do want to set this for June 6th. I do want to go speak with her as well to try to get either a resolution or see if we can get a bond. I just hadn't had the chance to do that yet, unfortunately, but I do want to try to get her resolved quickly if there is a resolution to be had.
What about June 6th?
That's fine with me, Judge.
No objection.
All right, June 6th.
One more week and we'll get it. We'll try to get it wrapped up. Try to see if we have time, sir.
Well, you can still, Flowers get.
And then we have those two at 1:30 and.
All right, do you want to do Copeland now? Well, let's do Henderson real quick.
Mr. Williams.
Yeah. Yeah. I just got to talk to him. Yeah. Okay.
What about Michael Johnson? Michael Alfred Johnson? What about, we did him already? All right, this is, well, we're going to do Mr. Henderson, aren't we? Real
I
quick.
think he said he was gonna go see him.
Oh, okay. All right, so this is Andre Copeland.
Yes, sir.
All right.
Judge, I'm gonna call Dr. Harper as a witness and she's present. so-
All right. Come on up, please. Dr. Harper, would you please raise your right hand to be sworn? Do you swear the testimony you give for this course is true, so help you God?
I do.
Thank you.
Thank you.
Go ahead.
Good morning. If you just please state your name for the record.
Dr. Julie Harper.
And Dr. Harper, what is your occupation?
I'm a licensed psychologist.
Are you licensed in the state of Florida?
Yes.
And do you routinely do evaluations for defense bar wherein you help us decide if there's any mitigating factors or circumstances for someone in the event they're being sentenced?
Yes, that's a type of evaluation that's often requested.
And as it pertains to Mr. Andre Copeland, Did you do such an evaluation for him?
I did.
Judge, may I approach the witness? Exhibit A. You recognize that document?
Yes, I do.
Was that document prepared by you?
Yes.
What were the dates that you visited with Mr. Copeland in order to put together this evaluation?
The exam dates were June 21st of 22, October 17th of 22, and November 30th of 23.
Even though the report date says May 1st of 23, it's a combination of all those dates?
Yes, I'm sorry. The report date is actually March 1st of 24. And review in preparation for today, I saw that I had furnished that report to you in March. And so that is a typographical error.
And so that the state is on the same page with us. Is it a 5-page document?
I believe so. Yes, it's a 5-page document.
As a result of your evaluation of Mr. Copeland, have you determined whether or not you believe that he suffers from some mental health issues?
Yes, that was my opinion. He has 2 different psychological disorders.
And what exactly are those disorders?
He has major depressive disorder, and that is something that has been present in his life in a recurrent fashion, meaning he had initial depression, a type of brief resolution, and then the depression returned. So that would be considered recurrent. It's ranged as significant to the level of severe to have some suicidal ideation, but at the time that I was meeting with him, I would term that it was in the moderate range instead. He also has an unspecified anxiety disorder. At one time, that was diagnosed as post-traumatic stress disorder by a different provider. During my evaluation with him, I found that he had mixed symptoms of anxiety, which would be typical of generalized anxiety disorder, meaning a general worry, stressors that exceeded his coping skills, a tendency to have some physical complaints associated with anxiety. And because he has been through traumatic incidents, such as being present when one of his relatives was shot, he has some symptoms of post-traumatic stress disorder. Because he has a combined effect of both of those kinds of symptoms, I gave him an unspecified anxiety disorder, meaning that if he were to present for treatment, the clinician could treat, all of the range of anxiety symptoms.
And do you believe that these issues that he suffers from need specialized treatment in order to deal with them so that he can cope with society?
Yes, I think that he's had difficulty coping with his stressors. And so you can use cognitive behavioral therapeutic techniques to learn to think about the impact that the stressor is having on you, to allow you to make decisions about how you would like to react to that stressor in a different manner, to have some more automatic responses for the anxiety, to calm and ease his nerves and settle his physical state. And also for the depression, because he has a tendency to feel very lonely and alone. I think that working on a support system, allowing him to see, the people that are present for him in his life, also helping to work towards his goals, because having a child has relieved some of his depression because he's got something that he's motivated and looking forward to future time with his child. But of course, with the anxiety as to, raising the child, I think that somebody to talk over all of that in counseling would be best.
Do you believe that he's amenable to seek the help that you're suggesting in order for him to become a better citizen?
I do think so. I met with him 3 times. During that, I administered a test that would basically assess his effort in participating, speaking with me. He was disclosing symptoms. During that, it's called the Miller Forensic Assessment Test, and he was open in disclosing symptoms. I do also feel that he hasn't had a lot of psychological background, so over the course of meeting with me, he was able to put things into words, kind of learn how to describe the emotions that he was experiencing. So I think at this time, he is actually in a really good position to participate in therapy and benefit from it. He was, motivated to meet with me, and 3 sessions is certainly a commitment, to get through his evaluation. I feel he would do the same with the clinician. Sure.
Sure, I don't have any questions I would offer in the evidence.
Any objection on that? All right, this will be admitted as Defendant's Exhibit A. Ross?
Dr. Harper, I think I just
Yes.
have a few questions. The trauma symptom inventory test, that was something that you administered to Mr. Copeland, correct?
Actually, the test that I administered was the Miller Forensic Assessment Test, and so that was an error in my sources of information.
How was that administered?
It's an interview, so you record the duration time. You ask questions that have to do with whether or not, well, I don't want to give the test questions away, but basically, you're asking questions that include some real psychological symptoms and some symptoms through the way that the questions are written that may not be real, or they could be feigned symptoms or suggestive of exaggeration. So you're using a booklet or a protocol to administer the test, and after that, you score the person's responses, and then you compare that to a statistical, the odds of a person being a true patient versus being somebody that would not be considered a psychiatric patient.
And was the MFAS test the only test that you?
Yes.
Nothing further, Your
All right,
Honor.
thank you.
Thank you.
She's free to go.
She's free to go, yes, sir. She's got other commitments. I think she's got to take care of children or something.
Thank you.
School's out for summer or something like that. Thank you, Dr. Harper.
All right, next.
So Judge, today we're here for sentencing, and the reason we had Dr. Harper come and testify is that she had done the report. We believe that Mr. Copeland, his prior record is little or none. I think there's like having a tag not assigned correctly on a vehicle in the past. The bottom line is, Judge, we don't believe that even though a score sheet, no vehicle registration and no insurance is what his two misdemeanor priors are. We don't believe that even though the score sheet is such that it suggests that the defendant should be sentenced to state prison, that is the correct outcome in this case. He has the basis for this purpose. He has no prior record, and this event occurred. There's nothing aggravating about it other than the event happened. And Dr. Harper believes that he does suffer from a mental health issue for which he needs specialized treatment, and he is amenable to receive that treatment. So in reality, Judge, I'm going to go out on a limb and ask the court to consider not adjudicating him guilty because he has zero felony priors and just two little misdemeanors, no vehicle registration and no insurance. I'd ask the court to consider putting him on probation for a period of 3 years, withholding adjudication, and any other special condition the court believes would be appropriate at this time.
Judge, did the court have an opportunity to review our sentencing letter as well as the PSI?
Got it right here.
Is the PSI on as well? You have a copy if the court wishes.
Let's see. I've got a stack of things I reviewed. Let me see that PSI. I may have left that on my desk.
Copeland is before the court on traveling to meet a minor for sexual conduct and soliciting a minor for sexual conduct. Mr. Nopes referenced getting a withhold, however, traveling to meet a minor for sexual conduct is a secondary. I don't believe the court will be able to withhold on over the state's objection, given the second-degree felony. We're asking for 5 years in prison, followed by at least 5 years of sex offender probation with GPS, curfew, no internet-capable devices, no contact with minors besides his biological children, and sex offender treatment program. The score sheet reflects 84.4 points, which provides a presumptive sentence of 42.3 months in state prison, up to a maximum of 20 years. And I know the court has reviewed, but briefly, during an operation by the sheriff's office in August of 2021, this defendant solicited an officer posing as the mother of a 13-year-old child for sexual conduct with that child, and a different undercover officer during the same operation, posing as a 14-year-old girl online. And then he took it one step further and traveled to meet that 14-year-old for sexual conduct. We solicited 2 separate officers in a single operation. As the court's well aware, downward departures are a 2-step process. First, whether the court can depart, that is, whether defense has provided a legally sufficient basis. The second is whether it should. Defense is asking for downward departure based on Mr. Copeland's need for specialized mental health treatment, that it is unrelated to substance abuse, and that he's amenable to treatment. All 3 of those prongs must be met. First thing defense must show is competent, credible evidence of a mental health diagnosis or disability. There's a lot of interesting discrepancies between Dr. Harper's report and what Mr. Copeland relayed himself to probation during his PSI, Order of Pretrial Services at the beginning of the case. When he was asked by probation on March 4th, he said he was in good mental health. He never had any mental health issues growing up. He was not seeing a doctor for any mental health-related problems. This was verified by his mother, LaKenya Foster. He rated his physical and mental health as good, the highest rating given by probation as an option. So both the defendant and his mother disclosed that he had no mental health issues or physical health issues to probation. And within this court's own file on May 9th of 2022, he was interviewed by pretrial services. He didn't report having any mental illness. He's claiming now that he has major depressive disorder and unspecified anxiety disorder. But I'd ask the court to consider what that diagnosis is based on. If you look at the sources consulted in Dr. Harper's report, the MFAS test seems to be the only test that she conducted. And that's a test for feigning psychiatric illness. And it says he tested at the threshold where malingering or feigning mental illness should be considered. There's also no independent medical records, no jail records, no prior doctor evaluations to corroborate anything that he reported to Dr. Harper. I'm not sure what case was referred to under the sources in her report, but it does list the Pensacola police report that includes an autopsy report and an 911 call, none of which were part of this case. So we don't believe defense has met their burden to even show the existence of a mental health disorder with competent, credible evidence. And again, his issues need to be unrelated to substance abuse. While he told probation he doesn't have any issue with alcohol, rarely drinks, and has no issue with any other illicit substance, he told a very different story to Dr. Harper. He said to Dr. Harper that he uses marijuana to remain docile, that he feels constantly stressed, paranoid, and antsy. He reported using lean and codeine from 18 to 20 weekly, and ecstasy, Xanax, Percocet, and codeine 3 to 4 times a day, with the highest rate of use in 2019. Even when he's legally able to consume marijuana is contradictory within the report. It says that he got a marijuana card in June of 2020, but later in that same report, it directly contradicts that and says he got it 3 days before the June 2021 appointment with Dr. Harper. And while he denied using drugs on the day of his arrest to Dr. Harper, if you go back and look at the messages that we contained within our report, he's asking the 14-year-old, in response to what he's up to, he says, "Ling," and "smoke." And later he asked the undercover if she smokes. Now, what does that mean to most people as a vernacular? It's not cigarettes these days. We don't believe his issues are unrelated to substance abuse. Second prong is the need for specialized treatment. Dr. Harper's opinion is that he needs mental health counseling, depression management, and some coping skill deficits addressed within those treatment programs. Judge, those are not specialized treatments. They're very common. They're widespread. Further, she doesn't mention a specific facility or plan or any sort of program in place as far as how his treatment plan would proceed. We don't believe defense has met their burden to show need for sufficiently specialized treatment either. Lastly, defense must show that the defendant is amenable to treatment. And Dr. Harper, when asked point blank by Mr. Nopes if he was amenable to treatment, said he was based on the MFAS test and those results, and that he had showed up to the 3 meetings indicating that he would benefit from therapy. Amenable to treatment means a reasonable probability he will successfully overcome the mental disorder through the treatment program. We don't believe that we get to that third prong, but again, we don't believe that's been shown in the testimony presented today by Dr. Harper. However, as the court's well aware, even if they believe Mr. Copeland qualifies for a downward departure and the court can legally depart, the second analysis is whether it should. And the state believes it should not. The purpose of criminal court is not to rehabilitate the defendant, it's to hold him accountable for his actions and protect the rest of the public. The fact that these were actually undercover officers posing as children is irrelevant to his actions and should have no bearing on the outcome of the case. It's fortunate it was adults on the other end of the line in this particular case, instead of actual children being victimized. But that's exactly why law enforcement engages in this type of work, to protect children. And a lot's been said about the defendant and his life today. But let's not forget it's his own actions that brought him before the court. That he solicited 2 different undercover officers in this case. And I'd ask the court to really consider that. During one single operation, he was caught soliciting sex from minors twice. And had he been sentenced to these charges on 2 separate dates, he'd be facing sexual predator status. So for these reasons, we'd ask the court to sentence him to 5 years in the Department of Corrections, followed by 5 years of sex offender probation and the conditions outlined in our letter.
Judge, our position doesn't change. We understand the state's position. I would point out that the minimum score sheet is 42.3 months, not 60 months. The state's asking for 60 months. But again, Your Honor, the gentleman he really has no prior record. I mean, no insurance and no insurance and one other minor traffic ticket. Judge, we're asking the court to consider finding no vehicle registration and no insurance. Would find that we've met the mitigator and the court can consider giving him something other than what the guideline score sheet says.
How much time did you spend in jail?
Judge, I think he was in there for several months. 9 months.
9 months. You pled guilty to 2 counts, correct? 2 second-degree felonies?
One is a second-degree felony, I believe, is a third.
Third? What I'm going to do is based on his lack of criminal record, virtually no criminal record, is 9 months in jail. Dr. Harper's evaluation that he suffers from process anxiety, stress disorder from seeing a relative murdered in front of him, major depression disorder, anxiety disorder. I'm going to adjudicate him guilty on both counts and give him 5 years probation on count one with a suspended 42.3 months prison, and then a consecutive 36 months on count two probation, with requiring him to have some type of mental health evaluation and follow any recommended treatment, standard court costs, representation fee. Yes, Ms. Berrickman.
Judge, he was privately detained, so there's no public
Okay.
defender fee.
Would that be sex offender probation with the other?
No. Well, if it's required by statute, then I've got to do that. Is that required by statute? I don't think it is.
Sex offender probation.
All right.
The GPS monitor, if he is on any form of probation, he has to be on the GPS
All right,
monitor.
that. So, you know, because you had no prior record, you spent 9 months in jail, and you have this issue that Dr. Harper has diagnosed. I'm giving you, if you go to prison, it's because you mess up, okay? So it's a suspended sentence. So get this treatment, and you've done well in life until you messed up with this. So I guess you got your family out here. If you start running into problems or something, reach out to Dr. Harper or them, and don't mess up, because you got a suspended prison sentence, okay? You'll get credit for the 9 months you spent in jail, but if you hadn't had a clean record, I was prepared to give you, a substantial amount of time, and you were looking at 20 years. I think I was prepared to give you a substantial amount of time in prison, but because you admitted your guilt, and I remember seeing you in court numerous times for hearings. You were always respectful, so I'm thinking you messed up, but one time. So don't do that again, okay?
Judge, would you consider waiving the cost of supervision?
Yeah, I will.
Judge, what about contact with minors?
Is that a requirement by statute?
Contact with minors.
All right, you can have contact with your own child, but no unsupervised contact with minors, okay?
Internet-capable devices, given the nature of the crime.
I'm not going to do that unless I'm required by statute. You basically need to do that to get a job or attend counseling and stuff, so. But they can spot you if you're messing up. They know if you get on these wrong internet sites and stuff, and don't mess up. Okay?
They would respectfully object to downward departure basis.
All right, and that is, the defendant requires specialized treatment for mental disorder that is unrelated to substance abuse or addiction or for a physical disability, and defendant is amenable to treatment based on Dr. Harper's testimony, and also that the court finds that he had virtually no prior criminal record and has already served about 9 months in jail. So,
Yes, sir.
all right,
Thank you, Judge.
all right, thank you.
And Your Honor, GPS, $1 a day?
Yeah, yes. Okay.
Thank you, Your Honor.
is this?
Yeah, I'm ready.
Okay, now, we got Miss Flowers, or yours, Mr. Williams?
I've got the one, Judge. But Ms. Flowers can go. Judge, this is a plea to a misdemeanor.
Y'all are free to go if you want to.
Judge, this is Bradford Henderson. He's entering a plea on this case to a misdemeanor driving while license suspended.
Okay, Bradford. Mr. Henderson, would you please raise your right hand and be sworn? You swear the testimony you give before this court is true, so help you God?
Yes, sir.
This is 24 CF 97, State versus Bradford Henderson. You want to enter a plea of no contest to driving license suspended or revoked habitual traffic offender? Excuse me. That's what you were charged with. You want to enter a plea to driving license suspended, a first-degree misdemeanor, correct? Okay. Did you read and sign this plea and sentencing agreement? Are you aware of the rights you're waiving by entering this plea?
Yes, Your Honor.
Anyone force you or threaten you to enter this plea? Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here today? Are you happy with the work Mr. Williams done on your case for you?
Yes, Your Honor.
Court finds the plea is free and voluntarily entered. Court accepts it. Judge you guilty. Sentence you to time served, pay standard court costs.
Cost of prosecution, Judge, and
Oh,
PD fees.
Cost of prosecution and PD fees, and I think I said adjudicated guilty. Okay? All right, thank you.
Now, Judge, he's got another case that was recently put on the docket. It's going to be a grand theft. It looks like, I don't think the state's filed on it yet, but the arrest was for grand theft. He's asked that we go ahead and get appointed on that, and I've already advised the state of his offer to resolve the case. I don't see it getting resolved this time.
Has he been arraigned?
He has not, Judge, and I don't know off the top of my head if an information's been filed on it. I don't.
He did not get a public defender at first appearance?
Yes, sir, I did.
You did?
It's showing
On the
no
grand-
attorney on it
on the
as yet,
grand
Judge.
I'll point you then, you should have been given a public defender on first appearance. You've already had the public defender.
Let me bring it up and
They-
look. Maybe it's just
They said
because
they
I haven't
appointed a
filed a
public
notice of
defender, but I don't know
appearance
who it
yet.
is. I've been there since Friday. I'm doing a year in Santa Rosa.
You're already doing a year?
I got a sick son over there, Your Honor. That's why I'm just asking.
I got you.
10 minutes with this and just,
All right. Well, why don't we,
I can give you the case
who's the
number on it,
prosecutor?
Judge.
That don't matter to me right now.
It should
Who's-
be me. It should be
He's doing a year sentence in Santa Rosa County, he says. So y'all look at that. Why don't we bring him back June 6th?
That's fine with me, Judge, if the state can take a look at it by then.
The clerk just put this case on Friday, so I haven't even looked at it. I
Well,
haven't had a chance to look at it.
well, we'll put him for June 27th and bring him back June 6th if you can get it resolved.
Yes, sir.
I mean, if he scores out, he's already got a sentence in Santa Rosa of a year. If he scores out, no prison time or anything, see if y'all can work it out. If you can't work it out, then we'll do it. I'm not forcing you to do anything. I'm just saying he's got a jail sentence. I just gave him time served on a misdemeanor, and a grand theft is probably going to be I don't know what it is, but,
I'll be in touch with my colleague.
yeah.
All right. Thank you, Judge.
Okay, all right.
June 27th, the same court date that you had, okay? And then we're going to see if we can bring you in early, okay?
All right. Is that it?
Judge, I think that's all the cases I have.
Mr. Newland, what case have you got?
Zachary Gines for Mr. Kilpatrick.
Zachary?
Yes, Your Honor, I think the
Gines,
court may have
okay.
addressed it and potentially continued it, but I did just want to bring it to the court's attention. We filed a motion to transport Mr. Gines, but he wasn't transported.
Yeah.
And he's been found incompetent to proceed in Santa Rosa County as an order signed by Judge Duncan, May 21st, and we included that in our motion for incompetency in this case. 2 experts have found him incompetent to proceed. Judge Duncan's ordered him to go to Florida State Hospital. He is autistic and incompetent, and he is being held in isolation in Santa Rosa County Jail, and he's been there for 6 months. So we're trying to move this thing along. I don't believe the state has an objection to him being found incompetent to proceed. I guess it's a question of whether or not he needs to be here.
Why don't you just get with Ms. Barrett and see if you,
State's position is that he does need to be here because it is a substantial part of the case. This court needs to make its own finding at
Yeah.
competency, and he needs to be present, whether that's by Zoom from the Santa Rosa County Jail or physically.
no, we can't, I mean, he needs to be here. Didn't I already address this by saying we'll continue it to another date? June 6th?
I mean, the only thing is, Judge, you signed the order to have him transported on the 17th of May, and we're now on the 28th, and he's not here.
Well,
So the 6th of
yeah.
June is next Thursday.
I'm sure that y'all can get him transported, can't y'all, by June 6th here?
Well, like I said, Judge, I mean.
We'll get him
10 days.
transported. If he's not here on June 6th, then whoever's in charge of transportation will have to appear in front of me and explain why he wasn't transported, I guess.
Sounds good. Well, we'll get you the order today for the transport, and we'll see where we go.
I thought I already signed one, you said.
You did for today?
All right, get me another one then for June 6th.
We'll see you then.
Get it today.
Understood. All right, thank you, Judge.
Okay, thanks.
I could briefly address something probation brought up for Mr. Copeland's case. Because he is going to be on sex offender probation, until he completes his risk assessment, he can't have contact with minors as part of sex offender probation. They wish for me to clarify that.
Well, except for his own child, right?
None is my.
None?
Until he has his risk assessment, unless the court wants to say he can.
Well, I'm gonna say he can with his own child.
So no unsupervised contact with minors except his own.
Right.
Is that what we're going?
Right. All right, Ms. Flowers, are you ready now?
Running a bit late to court.
You were, you didn't delay anything, so, okay.
I'm glad. Thank you. Ms. Sword is here. This is Lindsay Marie Sword, and 23 CF 2627. We have a plea, if I may approach.
All right. This is 23 CF 2627, State versus Lindsay Sword. Would you please raise your right hand? You swear the testimony you give for is course of truth, so help you God?
Sir.
You want to enter a no contest plea charge of fleeing, attempting to elude. Is that going to be a third-degree felony, Ms. Flowers?
Yes, Your Honor.
And leaving the scene without giving information and resisting an officer without violence. You want to enter a no contest plea to those charges? Did you read and sign his plea and sentencing agreement form? Do you aware of the rights you're waiving by entering this plea? Anyone force you or threaten you to enter this plea? Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here today? Are you happy with the work Ms. Flowers has done for you on your case? Court finds the plea is freely and voluntarily entered. Court accepts it. Count 1, a judge guilty, sentence to 1 year community control, followed by 1 year standard probation, 515 court costs. $150 cost of defense. Count 2, judge guilty, sentenced to time served. Count 3, judge guilty, sentenced for time served. And I think that's it, right? Okay, thank you.
Request of supervision fees be waived, Your Honor.
Okay.
Sure. Your Honor, this is David Anthony Fiducia. He's just going to quickly sign a plea that we've already gone over. She signed on the wrong line. In case number 21 CF, sorry, 667, that's a VOP, 21 CF 1433, that's a VOP, and 24 CF 577. It's not on the plea, but I'll get it. If I may approach.
This is 21 CF 667, 21 CF 1433, State versus David Fiducia. Mr. Fiducia, will you please raise your right hand to be sworn? You swear the testimony you give for this court's the truth, so help you God?
Yes, sir.
All right. You want to admit that you violated probation and enter a plea of no contest to fleeing and attempting to elude a law enforcement, a third-degree felony, and driving license suspended or revoked, a third-degree felony, and a third conviction. So you want to admit that you violated probation and plead no contest to those charges, correct?
Yes, sir.
Did you read and sign this plea and sentencing agreement form?
Yes, sir.
Are you aware of the rights you waived by entering this plea? Did anyone force you or threaten you to enter this plea?
No, sir.
Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here today?
No, sir.
Are you happy with the work Ms. Flowers has done for you on your case?
Yes, sir.
Court finds the plea and admission is freely and voluntarily entered. Court accepts it in 21 CF 667. Judge guilty, revoke and terminate probation, sentence 11 months, 29 days, county jail, credit for time served from his current arrest, concurrent, $100 VOP fee, $150 cost of defense to collections. In 21 CF 1433, you're judged guilty, revoke and terminate probation, 11.29 days, months, and 11 months, 29 days, I guess, jail with credit for time served from the most current arrest, concurrent, $100 VOP fee, $150 cost of defense to collections. In 24 CF 577, count 1 and 2, judge guilty, 11 months, 29 days jail from the most current arrest, concurrent, standard court cost of defense $150, payable all within 120 days of release into collections. So everything is concurrent, correct?
Yes,
And, okay.
he's waiving his prior credit for time served, just getting the credit from his most recent arrest.
And that date was what? You know his most recent arrest? March 6th. So you got approximately a couple of months in on that. So, okay, well, you'll probably be out within 6 months or something like, with credit for you. I see you're a trustee, so, you know, you're attained trustee status, so, you know, I think you get extra credit for time, extra gain time and things like that, but bottom line, just don't mess up anymore, okay? Okay.
I'm going back home to my kids.
All right. Okay, anything further on that? On this case? Okay, thank you.
I have to address this with Judge Ward, so, yeah. Sorry, okay.
They give you a worse-looking jail suit for trustee than they do for regular.
Your Honor, this is Haley Bryant.
Okay.
This is, I believe, her VOP arraignment date. We would enter a denial at this point, and if we could just set her on the next VOP date, I need to review the discovery with her and the offer.
June 27th, is that it?
Yes, Judge, and we would ask for a hearing on that date, just to get it resolved.
Okay, thank you. Thank you.
Your Honor, this is Christy Hawley. We would enter a denial for purposes of today and ask that we set it for the next miscellaneous VOP date.
All right, Christy Holly, 21 CF 96, or is it 83096?
Judge, I have 3096.
3096, okay. So we'll set it for June 27th.
Not a hearing on that one. I
Okay.
think we'll have a resolution.
All right. All right, thank you.
So June 27th. Your Honor, this is Erica Varner. She is on today as a miscellaneous. I believe that she had a pretrial detention hearing, and because she has a violent felony offender of special concern status, she's not eligible for a bond. But I would like to get this set, I guess, for the next miscellaneous date, and we'll be speaking before then.
June 27th?
Yes.
Okay, thank you.
Is Bobby Joe Booker? Your Honor, I have, I just wanted to point out, I don't know if there is a resolution, but I did have, I guess now, 4 clients that were on the docket that were not transported. So I know we're finished with court for this morning, and I do have, I'm not able to return this afternoon, but if I could.
What about, do you want to put them on June 6th?
Do we have a date on Thursday? 5:30? Is there a miscellaneous date?
There is.
I've got, it was Talia Derm.
I don't have them on my docket. I don't have you as anyone else.
They're on the clerk site docket, and I just went by that. But I'm having my assistant file another notice of hearing, and it does show up on each of their cases on Benchmark, but for whatever reason, I guess it wasn't coordinated, but,
You want to do it on May 30th?
yes, that would be great.
How
I'll
about-
file a notice of hearing, and once it's set, I'll just send it straight to the jail to make sure we coordinate transportation for those 4 people.
Which ones are bond hearings?
Bond
Because I know
is
Durham is.
Derm, Williams, and then Robert Woolery and Booker were pleas,
Okay.
if that's okay
So
with
we're
the
gonna-
state.
State has no objection.
All right, we can maybe take care of those cases.
Yes, I'll get those notices filed.
Let me see up here for just a second. Off the record.
Dixie Dan Powell and Powell Injury Law, 850-306-2667.
Backbone Bakery Cafe is 2 blocks from the courthouse on Crestview historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by. We're located in Court Plaza. Stop by and let us help you be healthy.
Is there anything else this morning?
I don't have anything else.
We just have a suppression hearing again, or this afternoon on two? Okay.
And we